I think then anytime the police show up, it's going to be custodial.
Then for that reason,
With that argument, it would be.
well, for that reason, and then leave this on Zoom.
Sir, can you please state your name?
Emmanuel Uduchuka.
Time for defendant's motion. I don't.
Yes, today's the date and time for our Walker motion to preclude statements that Mr. Uduchukwu made to the police at a interrogation, well, de facto interrogation. I'm not, do the people have a witness? It's our motion, but I believe it's the people's burden, my understanding of Walker. I don't know.
Well, I have to first of all determine that a Walker hearing would be necessary.
Okay.
I mean, I think that's the first step.
Okay.
And if I do, then we'll go from there.
All right. So I can make
you can make your motion as to why you make your argument as to why you believe that you'd be entitled to a Walker hearing.
So at the time of the interrogation, my client was under 18. Not read any Miranda rights. The police officers presented themselves to his home.
Well, Miranda is only going to apply to a custodial interrogation,
right? So, but just because he's not in the police precinct doesn't necessarily mean that he had control over himself or the other individuals in the room had control over themselves. The police presented themselves at the home. They told their father that they had to speak to them. They did not ask. They entered the home without an invitation. Once father opened the door, they followed him inside. There's a lot of procedural incorrectness on the part of the police, and that caused my client to make incriminating, which is why this is more of an interrogation, a custodial interrogation, than an out of custody interrogation. If they're using these statements against my client, he does, need to be.
Well, I just want to step back because first of all, it has to be the issue of the custodial nature of this encounter, doesn't there?
Well, what made this, my client was not free to leave. The police positioned themselves based on the video between the door and him. He was not free to move about his home. They told him where to sit, where to speak to him, and they told him what to say.
So he wasn't free to leave?
He was not.
Both of his parents were there.
They were.
Were they also not free to leave?
They were not.
Did the police say that to them, or was that their feeling? I mean, I guess I'm trying to.
They did not say that to them, but they stood in between them in the door. There were 3 police officers. All were in the home during the session, if that's what we want to call it, until it's deemed as other.
Okay, go ahead.
When they first arrived, they told the father, "We have to speak to your son." They did not ask if they could speak to the son. They did not make a request. And so the father, as seen in the video, and I'm happy to show those videos to the court, is standing in between the door and the police officer before they get in, with his hands up, bracing the door as to not let the police officers in, as they continue to say, "We have to speak to your son. We need to speak to your son." Afterward, father puts his hand down. He turns to go into the home, and the police officers follow him. He does not invite them in. They do not ask if they can come in until they are already inside of the house, starting the conversation. After that, the door.
So they just push past him? I guess
No, the door's open and they follow him around. Would it be better if we just.
Did the dad try to close the door?
Not.
Okay, go ahead.
Once Officer Masterman is in the house, he says, "Oh, can we come in?" But at that point, Your Honor, he's already in. He's an officer. These are not, sophisticated people who have a lot of interaction with the police, who feel that they have the ability to say, "No, you can't come in," after the police officer has already entered the home.
So I'm assuming by that part of your argument, he didn't ask them to leave, right?
He did not.
All right, go ahead.
And so once the question and answer session begins, they tell my client, Emmanuel, who is a child at this time, to have a seat. He sits down, they pull out a chair, they tell him where to sit and what to begin to tell them what happened. My client has no information about what happened. He is a minor. And during the course of the interrogation, the parents do eventually step out of the room at my client's behest. Again, my client is 16 at this time. He has no understanding about what he's saying and the implications, criminal or otherwise, that it would have on him or his family. So for him to make that judgment and for the police officers to encourage it, which is what they did, it was grossly improper.
How did they encourage it?
Well, they said
saying that they left at your client's behest.
The parents left at my parents said, "Okay, my parents can leave," and the police officers said, "Yeah, can you all leave?" This is his child. This is not someone who is often operating without his parents. And I think I should bring to the court's attention.
Well, but then wouldn't it be incumbent, if that were the case, upon the parents to say, "No, we're not leaving"?
Yeah, it would be if the parents had English as a first language, have been in this country for a long period of time.
So that's the reason they didn't?
No. Your Honor, a lot of times when you have children of immigrants who do not know and understand,
I understand you.
They rely on their parent. They rely on their children.
I understand that, but so they leave. So the parents leave.
Mm-hmm. They step into another room with an officer.
Okay.
And they are followed by an officer, adding to the fact that they don't feel free. They don't leave the building. They don't leave their room. I mean, they leave the living room to go into a back room with an officer who goes with them, adding to the fact that they are.
Makes sense though.
But it's custodial in nature. It does make sense if you're in an in-custody interrogation.
No, it makes sense for officer safety.
Yes, but it also adds to the custodial nature of the interrogation.
Okay.
If they're not free to move about their home without being followed by the.
Oh, you didn't say that. They were, an officer was viewing them while in the home. That's a whole different concept, counsel, than to say that they're not free to leave or they have no freedom of movement.
They have no free, if they're going somewhere in their home and they're being trailed by an officer for his safety or otherwise, it adds to the custodial nature of the interrogation, of the entire presence of the police being there. That is my purpose.
I think then anytime the police show up, it's going to be custodial.
Then for that reason,
with that argument, it would be.
Well, for that reason, my client deserved to be read Miranda rights before he said anything that was remote.
No, I don't agree with your conclusion. I'm just saying, if that is indeed it, then every interaction with police is always going to be custodial, and we know that not to be true.
Yes, we do. But when a police officer controls your movements, stands between you and the door, comes in uninvited, without a warrant, controlled my client's movement, controlled his father's movement, told him to sit here, told him to stand here. When those type of things are going on, it adds to the custodial nature.
Okay. Go ahead.
When they're standing in between them and the door, when they're asking for statements that are incriminating, that is what makes it a custodial interrogation that Miranda should have been stated, and it wasn't from beginning to end. And they use that
interrogation. The fact that it's interrogation doesn't make it custodial.
No, but the fact that they are
just said though.
No, I'm sorry if I miscommunicated. What I'm saying is they're entering the home, refusing to allow the parents to leave, controlling the movements, and standing between them and the door is what makes it custodial in nature.
Okay, go ahead.
So those are the things that came in that were directed by Officer Masterman that prevented my client from leaving of his own free will and made my clients who not believe that they had any choice other than to have this conversation with the police that they did not want to have. Incriminating statements were made, and my client was not advised of his rights to remain silent.
The standard, though, isn't the reasonable recent immigrant, is it?
No.
The standard is a reasonable person.
Right.
So the police don't have to inquire, and the court doesn't necessarily look at that. I look at it on a reasonable person standard. Isn't that correct?
A reasonable person standard, yes, but we also have to have. There's also a level of empathy in their shoes.
I might ask of it. It wouldn't matter. I could feel however I wanted. That's not the standard I'd have to rule on, though, counsel.
The court asked why something happened in this course. Why did the parents leave when their son told them to? And the reason for that is because there is a level of misunderstanding between the police and this child who was raised here, who fully understands whose English is not his, who is his first language, and his parents who are getting translated information through their son. So that is why that is an important facet that the court should consider.
Okay. Anything else?
Not at this time.
Ms. Willinger.
Thank you, Your Honor. If the main issue is whether he was in custody, I think that the people certainly do not believe that he was in custody and have a different viewpoint to how the police ended up in the defendant's home. Yes, they did encounter the defendant's father at the door. They told him what they needed to speak to his son about, and he let them into the house to speak to their son. In defense's motion, they frankly misstate some facts that are not. Defendant spoke to police in, you kind of enter the house and then it's the living room and the kitchen. Always in the living room. They never went back to the defendant's bedroom and secluded him there. It says in promotion on page 14 that he finds himself in his bedroom sitting on the bed. He was on a couch in the living room. At some point, the police do discuss with his father, like maybe it would be best if you weren't here. Because his father is getting emotional about the situation. And then the defendant point blank asks his dad to leave the room. Certainly, yes, he is a child by law, but he told officers that he had already graduated high school, he was in college, he wanted to be an engineer. He certainly knew what police were doing there and what they were discussing with him, and he himself explicitly asked his father to leave. In addition, stating that the interrogation lasted 90 minutes is not correct. The total body cam time from police enter to exit is 60 minutes. And the time that the police officer asks if the father wants to leave, the defendant confirms, Dad, can you leave the room? And then from when family comes back in, is maybe 20 minutes, 15 minutes. He was not in custody. He was in his own home. His family was present. He had ample opportunity to leave the room, move to a different room, get up. Of course, inherently, there is something intimidating about a police officer being present in your home, but ultimately, they didn't arrest him. They didn't take him in handcuffs at that point. They told him what likely the next steps were going to be and what was going to happen next. I think though, from a perspective of custody, he was not in custody. He was not entitled to Miranda rights. And so from the people do not think that a Walker hearing on that, on statements made allegedly while in custody would be appropriate. If we're talking about voluntariness, the case law seems to show me that they would be entitled to a Walker hearing about the voluntariness of statements outside of being in custody. But I don't think that they make sufficient argument of the time it was in custody in this case.
Anything else?
As far as my client being sophisticated enough to know why the police were there, they told him why he was there, why they were there. So that could be it. I don't know what that means. As far as where my client sleeps in the house, the living room is his bedroom. So, but that's neither here nor there. Officer Masterman pulls a chair and tells my client to sit down. The officers are standing between him and the door. He did not, a reasonable person would not believe that they were free to walk past the officers or go into the back of the house into a different room where officers followed his parents. That is the inherent intimidation factor of police being there is not why he's not free to leave. He was not free to leave because of their positioning, of their strategy, which they discussed prior to going in. Had no way of knowing that he was not leaving at that moment in cuffs. No one knew that. 4 officers coming into your house, but you're not leaving in cuffs. I'm actually surprised as to why he didn't leave in cuffs. So, Your Honor, I asked you to find the that they were in, that it was considered in custody. The voluntariness we agree on. He did make some statements that I do not think he voluntarily made, but I do ask that we have a Walker hearing to preclude those statements.
There's all of this reference to the body cam. Does either side have an objection to the court being able to view the body cam?
Not at all.
All right. Well, here's what I'm going to do, and if we can get a copy of that, I'll set a decision on whether or not to grant a Walker hearing in this matter for June 11th, 2026 I'll set it at 3 p.m. You actually may, but if not, then I'll pivot it from the bench. I will also, pursuant to the preliminary examination in this matter, the date may change, but the defense has asked for one. I'll set it for June 23rd, 2026 at 9 before me.
I'm so sorry. I'm going to be out. Yes, you're
Probably going to need a Monday then. Are you just is that week?
that week. You're
That week. Do I have the 20? Okay. Well, the Monday the 29th work for council.
that would work, Your Honor.
1 second, please. Unfortunately, that doesn't work, but I'm wide open the 30th.
I can, but I can do the 30th, but I'd have to do the afternoon of the 30th.
That's fine.
Will it work? All right. 2 p.m. Okay. So I'll set it for June 30th, 2026 at 2 before me. Okay.
Just for clarity, Your Honor, there are several responding officers, several body cams.
Yes.
I guess my suggestion would be that I provide Officer Masterman's body camera.
I agree.
Okay. And
So I just get one set, not redundant.
Yeah.
Okay.
Officer Massimo was the leader, lieutenant. I'm sorry, don't have me misspeak his rank.
Yeah, it's just an officer.
Oh, he was just an officer. And so, but he seemed to be leading up the
But that,
investigation.
regardless of who's leading or doing whatever, that body can be, both parties believe will show me what I would be.
I believe so.
Absolutely.
Okay.
That on a flash drive and provide it to the court on Thursday. That is, I just think
That's okay. That's fine with me.
okay.
All right.
All right.
Thank you.
All right. Thank you.
Thank you.
Did you say your name for the court? Via hello.
All right. But
State time set for preliminary exam. It wasn't previously adjourned because the people had the CAC, Health Center interview had just been completed the day before, and or defense counsel had time to review them. There was a bond violation filed by the deputy here based on statements made by the victim in the child access center interview that her mom had been contacting her either directly or through the grandma, which we staying with. The people admittedly do not have a victim present here today. I think it's going to have to be a situation where I have deputies physically go and get her along with her guardian who she's staying with. But I am going to ask for an adjournment for that purpose. I also think that an adjournment would behoove the defense in obtaining potentially a better offer, because my main focus here is seeing the defendant sober, seeing her as a sober parent, and any additional time sober is something I would consider an extending offer.
Johnny.
Yes, Your Honor. So we did adjourn the last preliminary examination, so both parties could review the recorded statement in which the child adamantly denies the strangulation, indicates that she made it up because she was mad at her mom and she had seen her mom being strangled before by her dad. And so that's where she came up with that. She also talked about people having rabies and a variety of other information that, you know, she's 7, so it's to be taken with a grain of salt. But my client adamantly denies the bond violation. She denies having contact with her since this case was pending. She denies the allegations against her in terms of any sort of assault, specifically strangulation, upon her child. So with that, she, we're here. We're prepared for the preliminary examination on the felony charges.
May I respond?
Yes.
I mean, since defense counsel is making statements and claims about what the victim said in the CAC, I would like to respond to those in that, yes, she stated that her mom did not strangle her. I will admit that. But she said that she called the police because her mom had assaulted her in other ways, and because her mom was so intoxicated that she tripped and fell with the baby in her hands, causing potential injury to the baby. And that this child did not know how else to get help other than calling the police and telling them that something maybe worse happened to her because she needed help from her mom, who was too intoxicated to take care of her, too intoxicated to take care of the baby. I have continued and ongoing serious safety allegations. I'm not even going to touch the rabies comment because that was made in relation to something that she also alleged that she saw the defendant do. So I'm just asking that this case not be dismissed today. If Your Honor is inclined to dismiss it, I will have the deputy return and I will at least begin the preliminary exam with very, very basic information.
Your Honor, Matt. But she, I'll take the credit for her get from the court. Please, you don't have medication.
Your Honor, again, my client denies the allegations. I'm pleased to report that she is sober and has been sober and is in treatment. So she's getting medication and she's in intensive outpatient treatment. She provided proof to my office. Regarding the adjournment request, obviously the court has the discretion to grant or deny the adjournment request. In this situation, it's unusual in that, because she denied the initial charge, I don't think that people could reauthorize that charge. Obviously, they're free to interview her and to continue a remand as a misdemeanor. And I prepared Ms. Holloway for that, if that is to be the court's decision today.
What about your client saying she didn't have any contact with her?
So, Your Honor, I have not never had any contact with her, period. Your Honor, I have not had any contact with Reagan, period. I have not been talking with Reagan through me or anything of that nature. I haven't even saw my daughter, and it's killing me because I love my kids. I do admit to being influenced.
I just think it's inexplicable that this child in the CAC stated that she was told that she's the reason her mom is in jail.
Yeah.
How else would she find that out?
Because he can come home with me and talk to you, and I'm had to explain to her that's why. So
That is the part that frankly bothers me, because presumably the child would not have known.
She don't have information.
Your Honor, the child did indicate she's living with multiple family members. Obviously, they're in the same family. So I don't know. Obviously, none of us know whether or not Ms. Holloway's had contact with her.
I hear you, but it seems just odd to me that the child says that and attributes that saying to a conversation that she's having with her mother. That takes a lot for a kid to do. I mean, if you look at those lines there, this child is very specific in terms of what she said.
May I submit an additional response? I'm not saying this is the case here because I don't know, but sometimes, I mean, Ms. Holloway was released after her arraignment, but she did spend some time in jail pre-arraignment. And again, I'm not saying this is what happened here, but sometimes she was actually released from the jail after her arraignment. So it is possible that she would have been on the phone with Reagan after she was arrested, before she was arraigned, before she was told not to have contact with her, and said something along those lines. Now, that I think at this moment, there is no specific information that it was a bond violation after she was released from jail. It could have been while she was in jail pre-arraignment, which wouldn't have been a bond violation. We would ask, if the court is inclined to grant the people's adjournment request, we would ask that her bond be continued. Again, there's no specific information that she's violated. I've been reaching out to her mom to try to talk to her this morning. Haven't been able to, but I'll continue to. And she's on these 2 tethers, GPS, Scram. There's been no violations of those since she's program. She's doing well. And so we would just ask that her bond be continued if the court isn't.
How would this child know or in some way fashion or attribute to her mother not to tell anyone that they've been talking?
Your Honor,
There's nothing.
again, I have had this conversation where the court has to, make a determination as to bond, presuming her innocent, but also to protect her daughter in the community. I will say, that she starts to go into all of the people she's been living with in the family who's been talking to her about the situation. At one point, she just leaves the interview room after mentioning, yeah, my uncle lives with me, and then she leaves, and then she comes back talking about, I don't know which family members are talking to her. I don't know who is saying what. Understand that people are making allegation that Ms. Holloway is communicating with her. She's denying the allegation. She's simply asking that if the court is inclined to set this for bond violation hearing, or continue the preliminary examination or adjourn it, her bond be continued so she can continue her treatment, which at the end of the day is, her goal is to stay sober, continue treatment. And, this is, she's known that she has faced going to jail all morning. I mean, she's been here. We've been talking about this all morning, and she understands how serious this is. We've talked again and again about the court orders. And even if this case was reduced to a misdemeanor, remanded, dismissed, I mean, the prosecutor and the court could still sentence her on contempt, right? On a bond violation. She understands that. She has never been in trouble before. She's trying to do right. She's trying to prove her compliance. And I know she's eager to speak up for herself. I've advised her to remain silent, but I know she's eager to tell the court that she wants to stay sober and stay in treatment so she can earn the privilege of reuniting with her children. I know she's working with the CPS caseworker as well, and complying with their plan moving forward. And I don't know if they have any additional information about this. I mean, last time I spoke with them was more than a week ago, so I don't know what information they have within the last week, but that could also shed some light if they were to have any additional information.
I did speak with this Yagi in that obviously was candid with her that my victim is not here today. And I wasn't opposed to, despite the allegation of contact, having the defendant's bond continued so that she can continue in this program and attempt to remain sober to be able to reunite with her children. I will say of note in listening to her jail calls when she was remanded on the past bond violation, it does appear she has a lot of support in her community, but a lot of recognition that she has a major alcohol problem, and if she wants to be around her kids, she needs to address that. So that was kind of my statement to Ms. Yagi, that I would be okay with her bond continuing. Would give me another opportunity to try to get victim care so that we could potentially resolve this and get defendant, I think, the treatment that she ultimately very badly needs.
Normally, if the parties are in agreement on the bond, I would follow along with that without a lot of hesitation. Ms. Holloway, I'm just going to tell you, I've got a lot of concerns about you.
I have to say you murder.
Because every time when I release you the one time, you violate.
Your Honor, I had just.
You're back here, and when I released you on the 19th, I think it was, I then have this indicating that you're violating the bond. I have real serious concerns as to whether or not you take what this court says. So if you want to tell me why I think I can trust you not to have communication, then here's your opportunity to tell me. But because I'll be honest with you, right now, I may be inclined to just send you.
Well, Your Honor, one potential additional assurance could be following up with the guardian. She signed the power of attorney over to her mother, who's, watching the child. And I don't know if the people have had any contact with her. I've played phone tag with her. I haven't actually spoken with her, but my client indicates that she, just like her godfather and I think her godsister's here, but they are like very strict and they take this court extremely seriously. And even if she hasn't proven her trust to this court, they are additional assurances that she will not violate. She will not have any mechanism from which to violate. Again, I'm not trying to say she would even violate, but even if she wanted to, she's saying that they would not let her because they are taking this very seriously and they want the end goal of reunification. I mean, this is a case where the interview seemed very clear that this is a case for reunification. And so the only way she could do that is by proving that she will comply. And understandably, the court has concerns. At this point, I would ask the court not to make a decision as to bond, perhaps set this for bond violation hearing. And maybe I could even subpoena her mom to come to court. Like if it's helpful to shed light onto where this contact is coming from, whether it was pre-arraignment or post-arraignment or when. But that could be an additional assurance that the court would have is the people in her life that are taking this very seriously and that have the end goal in mind for her to reunify. And the only way to do that is to comply with it.
For the adjourned preliminary exam date, does the 16th work for the parties?
Yes, Your Honor. June 16th.
Will that be enough time to?
Yes, sir, that works.
What I'm going to do in this case is I'm going to adjourn a preliminary examination to June 16th, 2000 before me. Of rights, Ms. Holloway. Oh, I really should lock you up today. I should do that for the protection of the integrity of this whole process, because I think you run right up to the line, you jump over that line, and you don't think anybody's going to do anything. It's like with your last violation request, they're telling you to get out of the area, you don't do it. I think at that time you were still drinking, because then when they got you, they said, well, take a PBT, which quite frankly, in this court's mind would have helped you. You didn't take that. And frankly, my view is the reason you didn't take it is because you knew you'd been drinking. But you knew your bond condition was that you weren't supposed to be consuming alcohol. Do I, as we sit here at this moment, believe that you had improper communication with your daughter? Absolutely, I do. Because nothing you say, at least at this point, I have any reason to believe. Told you when I let you out the last time, you're going to have to play by the rules. And if I find out, and if I'm sure you violated those rules, you won't be coming out of that jail. There's going to be nothing anybody's going to be saying to me that would let you out. I'm going to let the people, you have to, I guess, I'm going to let you go today. Over my Goodness knows I really do not want to. I'm going to give you that same ammunition that I gave you at the last hearing. Something comes back to me that you violated to any extent, any of your bond conditions, I'm just going to lock you up. I really should be locking you up pending a hearing in this case. And if it hadn't been for what the people said and what the ultimate goal here is, I would. So you can thank all them for that because my gut was telling me I should just lock you up. So you figure out which way you want to do it. I'm going to set a bond violation here for the same time as the preliminary examination. Come forth to me